Judgment in the appeal, Abela and others against Baadarani.
The judgment in this case will be given by Lord Clerk.
On the 30th of April 2009, Mr. Abela and his two companies issued a claim form claiming substantial damages for fraud against Mr. Baadarani in connection with a contract for the purchase of shares in an Italian company. The claimants had a good arguable case that the claim form was issued before the expiry of the limitation period, albeit only just before. The time for service of the claim form, unless extended, expired on the 29th of October 2009. In September 2009, permission was granted for the claim form and all other documents to be served on Mr. Baadarani at an address at Farid Trad Street in Beirut in the Lebanon. A challenge to the grant of permission to serve out of the jurisdiction failed, both before Sir Edward Evans Loam and in the Court of Appeal. Time for serving the claim form was extended until the 31st of December 2009, and permission was granted, if necessary, to serve Mr. Baadarani personally at the Farid Street address. On the 22nd of October 2009, a copy of the claim form and other relevant documents were delivered to the offices of Mr. Baadarani's Lebanese lawyer in Beirut, Mr. Azouri. That method of service had not been authorized by the judge, and it is accepted that it was not good service under Lebanese law. Mr. Azouri said that he had never been given instructions to accept service of documents on behalf of Mr. Baadarani, except in connection with some Lebanese proceedings. Mr. Azouri gave no indication of where Mr. Baadarani might be served. In April 2010, Mr. Justice Levison extended time for service of the claim form and granted permission for the claim form to be served by alternative means, namely on Mr. Baadarani's solicitors. Various orders for an extension of time were made. Mr. Baadarani applied to set aside the various orders that had been made to extend time and also sought to set aside an order permitting alternative service. That application did not need to be determined because Sir Edward Evans Loam made a declaration at the request of the appellants under CPR 6.375B and or 6.15.2 that the steps taken on the 22nd of October 2009 constituted good service of the claim form. The Court of Appeal reversed that decision and held that the various extensions of time for service of the claim form should not have been granted. The claim was therefore dismissed. Mr. Abela appealed to this court. The Supreme Court unanimously allows the appeal. I prepared the leading judgment with which the other justices agreed. Lord Sumption adds a short concurring judgment. The reasons were briefly these. Rule 6.15.2 can be used retrospectively to validate steps taken to serve a claim form, even if the defendant is not within the jurisdiction. Orders under Rule 6.15.1 and 2 can be made only if there is, quote, good reason to do so. The judge's conclusion that there was a good reason to make an order under 6.15.2 constituted a value judgment based on an evaluation of a number of different factors. An appellate court should be reluctant to interfere with such a decision. The Court of Appeal was wrong to say that the making of an order under Rule 6.15.2 in a service out case is an exorbitant power. In a case not involving a bilateral service treaty or the Hague Service Convention, it is not appropriate to say that an order may only be made under Rule 6.15.2 in, quote, exceptional circumstances. In such cases, there's no danger of subverting any international convention or treaty. In any event, it is no longer accurate to describe service out of the jurisdiction as exorbitant. The test under 6.15.2 is simply whether there is good reason to make such an order. The rule applies only in cases where none of the methods of service permitted by the rules have been successfully adopted, including any method of service permitted by the law of the country in which the defendant is to be served. A claimant seeking an order under Rule 6.15.2 is not therefore required to show that the method of service is good service under the local law. The Court of Appeal was in any event wrong to say that the judge had concluded that service of the documents on Mr. Azuri was good service under Lebanese law. If the judge had reached that conclusion, there would have been no reason for him to make an order under Rule 615.2. The only bar to the use of Rule 615.2, if otherwise appropriate, is the rule under Rule 644 that nothing in a court order may authorise any person to do anything which is contrary to the law of the country where the claim form is to be served. Although delivery of the claim form and other documents to Mr. Azuri was not good service on Mr. Baadarani under Lebanese law, it was not suggested that it was contrary to Lebanese law. Although the mere fact that a defendant learned of the existence and content of the claim form cannot without more constitute a good reason to make an order under the rule, it is a critical factor. Service has a number of purposes, but the most important is to ensure that the contents of the document served are communicated to the person served. The fact that a claimant has delayed before issuing the claim form is not, save perhaps in exceptional circumstances, relevant when determining whether an order should be made under Rule 615.2. The focus must be on the reason why the claim form cannot or could not be served within the period of its validity. The judge was entitled to conclude that an order under the rule was appropriate. The judge correctly took account of the fact that Mr. Baadarani, through his English and Lebanese lawyers, was fully apprised of the nature of the claim being brought against him. The claim form and other documents were delivered to him within the period of validity of the claim form. He also took account of the fact that service in Lebanon via diplomatic channels had proved impracticable, and that Mr. Baadarani was unwilling to cooperate by disclosing his address to the appellants. Whilst Mr. Baadarani had no obligation to disclose his address, his refusal to cooperate was a highly relevant factor in determining whether there was a good reason to make an order under the rule. The judge was entitled to take the view that an order under the rule was appropriate, notwithstanding the 3.5-month delay between the issue of the claim form and the application for permission. And moreover, despite the fact that the claim against Mr. Baadarani would by then have been time-barred.